All right, there we are. I think the recording has started. Yep. Okay, cool. And just so everybody's aware, it does come with transcription. So after the work group is, the session is over, I'm going to go ahead and put a copy of the transcript into the Dropbox. Was everybody able to access stuff? Because I think I might have sent the wrong link for the Dropbox.
I got in, but there wasn't anything new in it when I checked yesterday. So
Oh yeah, I think most of the stuff I stuck in there was middle of last week at the least.
I mean,
So,
all I saw literally was the notes from the um, the standards that we have currently, um, and maybe I'm misspeaking. So I'm going to rewind that. I got
okay,
in and I looked at stuff, but maybe it was just a quick stuff. It didn't seem like anything deeply substantive or something I hadn't seen before.
that's weird because okay. So what you should be able to access. How about I tell you that so that you have an idea of whether you're seeing what you should be able to see. Okay. There's probably around 30 PDFs in there.
Oh, that was not in what I looked at.
Yeah, no, and it's like there's some standards from California, Arizona, Washington, Montana, Florida. I think Arkansas is in there. Yep, Arkansas and Alabama. So like just a wide range of standards documents from other places. I'm going to take it that nobody's gotten those.
So I saw those
I
with
saw
the link
that.
you sent me today, Kevin.
Okay, so I have a feeling I sent out the wrong link. Let me go ahead and put the
Yeah.
right one.
And I did not see any of that.
Okay. I will say that
those, but you do have to dig through to find the dependency specific things.
yes, so there should be, I'm going to send the link for the overarching, like the big project that all of the work groups are working on together. And you'll be able to see in there what materials have been grabbed for each of the work groups as well. But dependency is all one. Let's see, get the link. Yep. Okay. Copy.
Maybe we could put on the agenda for you to give us some pro tips on navigating this so we can efficiently find what's relevant to us.
Sounds so I will say like the most important thing for these is just that they're examples of what other states are doing. And I will say that I put in here in this box a lot of stuff that's not part of this first round. Because this project, like we've got the qualification standards that we're tackling now, and then later we'll be handling the performance standards. And most of the places that I've looked, the bulk of what they've written is performance standards. And those can inform what we think are the right skills that people need in order to practice dependency law. But they would be more codified by this group in later. So there's a lot of stuff in there that may be tangentially related to what we're working on right now, but is going to be, so there's a lot of time to get through and read. And honestly, it's there for thought provoking. It's there to get examples. I'm not gonna, I feel like it would be really weird for me to direct attention towards things other than like, I've read a few of them. And if we're talking about something and it's like, oh, well, here's an example of how they handled it in this state. Is that something we want to look at as how we want to handle it type of thing? Really, the work group idea here is we want to get a sense of what the overview and what the standard should look like. We're going to have to tweak them to make them fit with the other work groups, and that there's something that we as an agency can reasonably implement. But like throw out everything that we currently have and don't use that as a model. we're gonna focus on, we've got a chance to do this from scratch. Let's do it right. Like, let's pick the things that make sense. The work group that I ran yesterday for the quasi-criminal, what we started off with was a broad look. What are the things in this field that we want to develop standards for? Kind of an outline of what the various components might be. And then we'll start looking in at specifics for each of them and moving towards, is there something that's hierarchical in here? We currently have dependency and TPR in a hierarchy. Is that truly something we want to retain? Is it something we want to move out? There's subject matter areas that we might want to split. This is kind of an open space to work through some of those concepts and figure out what we as experts in the field think makes the right sense for how practice works in Oregon. So before we get into that, what questions does everybody have?
I have some questions.
Go ahead, Don. You got it.
So if I'm understanding this, we have a timeline and
Yes.
a set number of meetings. So are we going to get an agenda in advance of every meeting and a summary of what you want us to be thinking about or have looked at before the meeting starts? Because that would make things move way more efficiently.
Sure. I will send out a summary with the notes and the transcript after each meeting. And I think we generally at the end of each work group have set, here's what we're going to look at for the next work group. Given that we're starting off with really broad, there wasn't really much to send for today.
Okay.
So. Okay. Any other questions before we jump in? Hopefully, there are other people who hopefully will be joining us as we continue. We'll see.
I will just tell you that the link said I didn't have access.
Yeah, that's you will have to, there should be a way to request access.
I did.
Shannon,
Yeah.
Shannon has
Okay.
to prove it. So yeah.
Okay. All right.
Okay, cool. Oh, there we go.
So are you resending the link, Kevin?
Did you not see it in the chat? I can go ahead and send it by email.
Oh, you put
as
it in
well.
the chat. Okay.
Mhm. Just recent email. Yeah. There. And then there's another one coming by email to everybody too. Okay, cool. So let me go ahead and share the completely blank page of paper that we get to start off with. So let's start with the big broad strokes. What we know we want to include as part of the work group product is anything under 419B that we pay for with state funds. That's most things except what's the word I'm looking for? Emancipation. Voluntary placement agreements, and adoption. We're going to work through that in this work group because there's a lot of similarity, but I do want to recognize, and I don't know, I've done one, but I've only done one. Who else has handled adoptions in the group? Okay. Okay, cool. And Holly, great.
Kevin, just to clarify, you mean being appointed to represent a party in a contested private adoption case? Is that what you mean?
Correct. When the
Okay,
court,
I just wanted to be sure.
Yep. When there's the show cause why the adoption shouldn't occur. Yeah. And we can anchor that to the case that grants if we need to. I'm not super worried about where we go with that. So, okay. So let's talk broad strokes. How do we feel that, or does anybody have any strong opinions on where there might be discrete areas that are different from others? I mean, straight off, I don't think that the same qualification standards that we use for TPR should be used identically for adoptions. That does not make sense to me. They can borrow from each other. I think there's a lot of overlap, but I would say it's a very different, you're working in two different worlds. They have a lot of similar interests, but the worlds are different. What we currently have is just dependency, and TPR. I would, at the minimum, add adoption to that. Does anybody feel differently about that or have a strong opinion one way or another? Okay. Are there things that we want to break out within this structure? We do want to cover the concept of voluntary placement agreements. I don't know, and we're looking for kind of general feedback. Is that something that should be covered under a different piece, or is it something that should be split out on its own? Dawn, did you have something you wanted to?
I just want to clarify, like, when you say dependency, are you talking about jurisdictional cases, whether the kid becomes a ward of the court, and inside of that, should a guardianship be put in place or should we break guardianship out and have a subsection of permanent guardianship? Because I have learned through my experience with working on these that it might be it might be subsumed, it could be subsumed, but there's different skills that you might need to have with guardianship. And
so I think there's a lot of different ways that we could tackle this, and that's kind of what I want the discussion to kind of move around is, do we think that, so, I mean, we all know that there's different permanency plans and each of them carries their own kind of different stuff that they have to deal with. Permanent guardianship has a very different procedure for a lot of jurisdictions than durable guardianship. Some of the permanent guardianship in jurisdictions has the same procedure as a TPR, but I've also seen some counties starting to file a permanent guardianship petition inside the case number of the dependency petition. So that's structure-wise. That's kind of, I think the first question is, how does this group want to break those pieces out? We're kind of looking for what is the consensus on what makes the most sense in terms of if we're going to have different requirements for different categories, we should know what those categories are first. And this is intended to be iterative. If we get partway through the process and it looks like, you know, we weren't really considering this before, but it really does sound like what we're meaning is guardianship needs to be split out, then we do it, right? Like this isn't gonna, this is meant to be kind of organic and eventually we want to come to a consensus on what these things should look like. Jennifer? Kinsey. Sorry, because there's two Jennifers.
So, of course, the Jennifers have to make it confusing. My question is, are we breaking this out so that we can think about the discrete requirements for each, or are we breaking it out as in you can be certified for this piece, certified for this piece, certified for this piece? Because I don't know that makes a whole lot of sense. I think every dependency attorney is going to have to also do TPRs and to a certain extent the permanent guardianships.
And that's something that we've had a lot of talk about internally before the work group is we currently split TPR out, but it's like saying, okay, but if every criminal case carried the possibility of a death penalty, like how what does it matter if you're misdemeanor or murder qualified? Like it's different, right? But I wholeheartedly agree that it may not necessarily be that we have to be mindful that as soon as you pick up a dependency case, there is the possibility of a TPR. And however we structure this, we need to be mindful that whoever's assigned to the case ultimately may need to handle the TPR. And there are creative ways we could work within that, right? We could say we can certify people for dependency, but also include provisions where if a TPR petition is filed, we have ways of managing that risk by having other attorneys involved who are certified for TPR. Jennifer Stoller?
Yeah, I mean, I just wanted to highlight that, if TPR is the equivalent of the civil death penalty, I think we also do need to be cognizant that somebody picking up their first dependency case ever, and it goes all the way to TPR, that person needs some support along the way.
Mm-hmm. So the kind of conflicting stuff, what we've been kind of conflicted about is we don't want to make dependency qualifications so onerous that nobody does it. But we also have to be mindful that there's short timelines and eventually you've got to know how to handle the worst of it, right? One of the ways that we have conceptualized possibilities here is having specifications not on the procedure, but on content. So you might, and keeping in mind that sometimes DHS doesn't allege what they really care about, right? So any case can theoretically be a sex abuse case, even if they didn't put that in the petition. Because maybe it comes up later and they're not interested in making the pleadings match what they actually care about. So this is going to be a complicated set of stuff, and that's really why we're relying on the experts around. Melissa, I think you were next.
So I was going to say that, and then that it's really, I think, one of the things to consider is that it's important to understand the issues related to a termination at the outset of a dependency because of the tactical decisions that you sometimes have to make with the future in mind and how that is going to shape your case and your jurisdictional bases going forward. I think, and I know that it might just be, there might be other creative ways that we can address that, but also I was actually having this conversation with someone newer to dependency today. Sometimes a contested permanency hearing might even be more critical to understand the termination ramifications than the actual termination trial, because by the time you get to the termination trial, you have very specific tests. Yes, it's complex and the stakes are high, but it's a little bit more straightforward and less
There's
nuanced.
elements.
Yes.
Yeah, there's
exactly.
elements, it's structured, there's nuance to how you argue, but there's a framework that you
Correct.
can
That's more
know
straightforward.
Yeah.
Yep.
I hear what you're saying. Okay. Jennifer Kinsey, I think you were next.
So I sort of in that vein, as someone who came out of law school relatively recently, like 6 years, 7 years, whatever, relatively recently, the TPRs are more easy to understand conceptually than a lot of the, oh, here's a hearing in front of a judge, but they're going to say stuff, but the rules of evidence don't fully apply. So I think when we're thinking about the standards for this, you kind of have to put it in 2, if not 3 camps of the hearings where you don't get the full rules of evidence, the contested hearings where you do like the contested jurisdiction, and then sort of the big TPR where there's a higher burden. I also wonder if having just a basic familiarity with courtroom procedure should be a component. And then on top of that, something like an open book test where you reference the bar book on dependency so that people get really familiar with what the case law is in Oregon for each of these different things.
So what you're talking about with that last piece is more how we might determine that people meet the criteria that we set out. We're at this first stage, what we want to be looking for is the criteria. And I'd say to some of what you were talking about, knowledge of the rules of evidence and how they apply to dependency is a crucial skill, right? And especially, I mean, there's some nuances with how business records work. What you do with multi-party litigation and when hearsay rules apply. Like you've got some very specific things in there. And I don't know that we necessarily need to be that explicit in the criteria that we're looking for, but conceptualize that we are opening the door to how people might meet qualifications. We may be able to create and or certify trainings that other people have created in order to approve people for on certain subjects. And like if you tick the box on A, B, C, and D, congrats, you meet whatever we call it. Like if dependency is the only one, then you meet that and we're good, right? So Dawn, I know you had your hand up earlier. Do you still was there something you still wanted to say?
No, I'm still thinking. I'll put
Okay.
my hand, I'm gonna think for a while on it.
Sure. Holly.
And I wanted to throw in a couple other like possible categories or discussions. One would be around ICWA and or ICWA cases, and like education and training and some kind of qualification to handle those. And the other, which Jennifer Stoller was so kind as to present to us in our group, was on the special immigration, the status cases, because that is like a whole nother thing that when we were alerted by our court about the possibility of having one of those, I reached out to YRJ and I was like, help us, because no one in my group had ever handled or dealt with that. And Jennifer was kind enough to do a presentation for us, but so another, because that's a whole nother layer of specialty and knowledge base that is beyond like any kind of this stuff. It's not even like related to a lot of this stuff we're talking about, but it's in 419B. So
I
right.
wanted to add to that. If we're talking about content, the possibility of a designation for aggravated circumstances or extreme conduct cases, given that that can change how things operate and it becomes an all or nothing at the beginning. So this is great discussion. This is exactly what we're looking for. So what are people's thoughts on what might serve Oregon best on this? Dawn, go ahead.
So kind of taking maybe a little bit of a page book from the adult system. We could have levels of certification that cover things like jurisdictional, like think about TPR is the death sentence for parents, right? Literally, we are killing off the biological family. I mean, I know judges roll their eyes sometimes, but that is what's happening.
Right.
You're illegally killing it off. Then you have, there could be some discussion about whether a jurisdictional trial is like a misdemeanor or are reviews like misdemeanors, and jurisdictional trials like property crimes, like where does everything fit? What skill, you have to have a different skill level. If you pick up a case, a newer lawyer to the system should not pick up a case where the allegation is child sex abuse, right? Because that involves the aggravated potential for it to default to the aggravated circumstances. So I think we have to start thinking about, do we think of, I would be a person that votes for us to at least think about different levels of skill levels for different types of cases. Now, we like continuity of representation, particularly in these cases that can last so long. And if they start to add some stuff in there, then how do you get the lawyer that's worked on the case? Could they demonstrate that they have the skills needed to keep the case at the higher level, or a co-chair to get them certified if the dynamic of the case changes? But if we are really throwing the old system out, you can't come right out of law school or be a year into cases and get, oh my God, I've got this child sex abuse case or the death of a child where they can't prove a homicide, and maybe they're going to charge or they're not going to charge, but you're in dependency land and everything your client says or does impacts the potential for being indicted for murder, right?
Yeah, that was me. 6 months in and I had an infant death case. That was.
So like, we might want to really, if we have the opportunity to rebuild and meet the criteria you described earlier, we might really want to start thinking about looking at it that way.
So I'm hearing hierarchy makes sense if we can figure out what the hierarchy might be. Jennifer, I think you're up next. Jennifer Kinsey.
Sorry about the last name. You can just call me by my last name. It's fine.
Sure.
So when we're thinking about the number of people practicing dependency and the fact that we need more people practicing dependency, particularly in rural areas, if we start breaking these out into these very strict hierarchies without having any financial benefit for people getting certified in multiple versions of this, in multiple hierarchies, then that's going to lead people to just not do it. And you're going to have people who aren't represented in these areas. My thought on having things like the aggravated circumstances, or it being like your first TPR trial or something like that, that maybe we can set up a system of mentorship instead, so that you would have somebody who's able to come in and help advise you on those cases once or twice, and then check off the box that you don't need that advisory part anymore, rather than make it an entire separate criteria.
So that is something that I think it's Massachusetts uses as part of its model, is that for the first year of doing care and neglect cases, you have a mentor. You're with a supervisor the entire year. There are other jurisdictions that it's not exactly the same, but Washington's civil commitment qualifications require you to attend. You can't do your first one on your own. Someone else has to be supervising you for your first civil commitment hearing. So there are absolutely ways that we might want to put that into our qualification standards. And I do like that's we were pretty sure that's like kind of what we might need to do here, because no one can walk into a dependency caseload fresh out of law school. Like that is a real high burden to do solo. You got to have somebody helping you out with that kind of stuff. Vicky.
So just to go back to your point, Kevin, you were talking about the aggravated circumstances, extreme conduct cases, and I don't think that people in a dependency practice can do them without also having a companion criminal practice experience, simply because of that overlap. I'm in 3 of them right now, and you're getting the case and you're seeing the evidence, and the first thing you tell your client is you can't talk. You can't talk to law enforcement, you can't talk to caseworkers, you can't sign blanket releases, you can't do anything, because we have to wait for that other shoe to drop. We have to wait for the possible indictment that's coming down the pike. So I don't think that especially ag circumstance extreme conduct cases, I don't think they can be done by somebody with only a dependency practice. I think there has to be some overlap with a criminal practice simply because it's so often they go hand in hand.
I don't necessarily disagree with you. Dawn?
Well, that sounds like a co-chair case or a double credit if you're double certified. Like if you, right? I mean,
Right.
part of
And
this discussion really is going to involve what is the state willing. I mean, the state expects us to be qualified, and it takes a lot to, like, we are, we do almost everything the adult lawyers do, but we do it backwards when we're in high heels because we need to understand brain development, and we need to understand the criminal consequences, and we need to understand how a criminal lawyer, government lawyer is going to go in and access DHS records.
You go, Dawn. You go.
Yeah.
That's right, sister. That's right.
So now is not the time for the discussion, but you can see that the level of certification requires a recognition of the resources that go into these cases.
yes.
And so we should start thinking about like double certifications or expectations of a co-chairing, getting a co-chair on board for the lawyers that aren't able to get that level of certification because it takes years of practice to get there.
To put it in perspective, and I'm only relaying this for where we currently are. Currently, dependency requires lesser felony experience, and I mean, you can get around that with other child custody experience and sitting on 2 cases or watching 5, which that's not skill oriented, right? Like that's not experience. That's not a good. I forget the word I'm looking for. It doesn't fit well with the kind of experience that people really honestly need in order to do this solo. And that is what we're looking at here, remember, is what would it take to do it solo, with the caveat that there may be some places where we want to put in the structure of, you're not expected to do this solo. Here's how we want to make sure that it's being supported. Jennifer Stoller, I don't necessarily disagree with you on that.
I know you don't make all the decisions, Kevin.
Yep. Vicky, I've got your hand up, but I don't know if it's just from when you were talking earlier or if you're good. Okay. Melissa.
So the only other thing I would add to the discussion around aggravated circumstances is that you either need to have adult criminal qualification, in my opinion, to be able to advise the client, or have the experience and understanding that you're outside of your realm and get somebody on board to consult with and to be advising your client. So, I mean, I can think of circumstances, even in delinquency cases, where I was fairly certain based on just the things that were happening that there was far more going on and that my client may need like a murder qualified attorney. And even though I had no information to support that, but my first call was to another attorney who's murder qualified and said, I think I need this type of attorney on this case, and then to OPDC, then S, to get that going. So you have to, I think, either have the qualification or enough experience and understanding that you don't know what you don't know, or that you're not qualified to handle that, and seek that out, if that makes sense.
So, and yeah, Rebecca, you're right. They don't always file that when they could. And then they hit you with it at the TPR at the end. Like, we could have done this, we didn't, but here's the 2-punch. Yeah, totally.
Well, and you might also already have a criminal attorney that's handling that side of the case. At least in the counties that I practice in, that would be what would happen, is that typically one of us would be appointed to do the dependency side, and then a criminal attorney, the criminal side, and we're just working closely together.
But they don't
Um,
know squat about juvenile cases is part of the problem. And so, and it depends on whether the criminal attorney is really willing to work with you too. Some are, and some are like, I got my case, you got, it's frustrating sometimes.
Holly.
So I want to preface my comments first with just, I don't know some of you, so that you don't know me, but I want you to know that I've been an attorney for 32 years, and I've been doing dependency law in Josephine County, Grants Pass, for 32 years, along with criminal defense until actually 2019. And so to all of your points, I mean, I agree from the standpoint of it's definitely been helpful to have had the experience in both areas of law. I no longer practice criminal, but I obviously still know a lot about criminal law. But in our county, we have multiple groups, right? Like I'm sure you all do. And so frequently, like more serious criminal cases are going to the public defender's office. We don't even do murder anymore in our consortium. And so if they've got the criminal, I mean, I think having the dependency lawyers trained well enough to know, like what Melissa was saying, is to go and work with that criminal defense lawyer just the same. And I've also done custody and divorces and all of those things for 30 years, is that my client can come hire me and can hire a criminal defense lawyer, right? So I think we have to think of it in that realm as well. What I would want is training. Like, I think one of the key components for all of these various categories is that we need as much training required as part of the standards, I think, so that we let lawyers loose on the public who at least have the education. I think about trainings years ago on if you have someone charged with sex abuse and they have a child welfare case, and what you should do and not do. And so focusing for the dependency lawyer on both, whether they do criminal law or not. And so I think that's going to be a large part of what I look at, because I'm also mindful of the fact we don't have enough lawyers in the state of Oregon to handle the work we've got. And if we make this so incredibly difficult, we're not going to have more dependency lawyers, we're going to have less. So I'm just trying to balance all of that in my thoughts and in my suggestions. But I definitely agree with all of you. I would like to have the most skilled lawyers doing some of the more complicated cases and or having that mentorship required. My lawyers in my group, I'm the contract administrator for our consortium. We have the only juvenile contract and have for as long as I've been a lawyer and then some. Is that I mentor my lawyers, whether, like Melissa said, whether it's required or not. If they're going to handle a TPR for the first time, because frankly, it used to say in the standards, you had to watch so many TPRs. That was one of the things. We don't even have enough TPRs here to watch. And you can't go get transcripts of TPRs because they're confidential. And so I just like trying to be mindful of all of those various components, and especially focusing on not just the places where there's lots of lawyers, but the places where there's hardly any lawyers, like in my community.
And that's one thing that we're cognizant of as well. Say, for instance, if ICWA was its own specialization or its own certification, in Multnomah County, it might be easy to find 3 attorneys who are ICWA certified, one for each, the mom, dad, and child, maybe multiple for multiple children. But in other counties, it may be less easy to find multiple ICWA certified. I mean, Benton County has like 4 primary attorneys doing the work in that jurisdiction at all, and getting everybody up. So yes, we have to be mindful of that. And sometimes to that point specifically, what does it mean to be ICWA certified, and what does it mean if you're not? If you're assigned to a case and you're not ICWA certified, Does that mean that it's not an ICWA case? Because it might actually be one, but if you don't have ICWA knowledge, you don't know what the right questions are to ask to make sure that it's being treated correctly. So we also don't want to set up that kind of a situation where everybody's just like, oh, this isn't an ICWA case. So they assign it to somebody who's not ICWA certified, but turns out that person doesn't know what questions to ask to verify that it's not. So like there are, so to bring back to kind of the central question that I think we've got for the dependency field, and I'm not including adoption or voluntary placement agreements in that right now, is, are we looking at something that is hierarchical based off of procedural gates? And or are we looking something where there are discrete content areas that have higher skill levels that we would want people to be able to achieve? We don't necessarily need this to be an entirely flat qualification system, but going too rigid in either direction is going to have impacts on the system that we may not want. So we kind of want to be careful about which ways we want to go. I don't know that we necessarily need to answer this question today, because we can work towards defining some of the specifics. There's been a lot of discussion about aggravated circumstances and extreme conduct so far. But that is a central question that we are ultimately going to have to answer is, do we have a hierarchy? Do we have content? If so, which ones are worthwhile? Which ones aren't? And where do we want that to land? Kinsey.
I think when we're talking about, particularly with things like specific content, things like ICWA, we also have to keep in mind that we're going to have to create, if we're looking at mentorship or some sort of advisory council, that has to be available to people who are in rural areas if there aren't any certified in their area. So it's not like they can come in person, sit down with them at the council table and help represent at each and every hearing, but to have somebody that can help advise on, okay, these are the things you need to look for. Remember, this is the case law that applies, things like that, so that if that's the direction we go, it's accessible to more attorneys.
So Massachusetts's panel, they have the two pieces to the system. They have the state public defender office, and then they have the panel of non-state public employee attorneys. And that panel has supervising attorneys who handle a region and assist with things like that. And I know that that is a part of the model that we are looking very heavily at implementing. And it is part of the plan to develop those supervising mentorship attorneys. So that is a component that we can be looking towards, right? And that's and there's a lot that's going to go into like selection of those supervision attorneys. We are nowhere close to that right now. I'm not even sure it's 100% going to happen, but that is a direction that may work and may be a part of what we're going towards and help fill that role. Dawn.
Maybe one thing that we can consider, building off of the training conversation, that one thing we could consider is that qualifications have a timeline to get certain trainings, and then the Public Defense Commission could help develop high quality trainings and provide trainers or resources to make the trainings available within the timeline. There are aspects of this work that really lend themselves to get the training before you take on this kind of case. Like ICWA is a good example. The immigration family, I can't think of the acronym, but it is similar to ICWA. It applies to immigration. The special immigrant and accompanied children, there are lots of sex cases. So maybe we could build that special piece in to the qualifications. If we qualify you within this time frame, you're going to agree to do this type. Right now we have a set number of hours, but we don't really tell people concretely what kind of specific training they need to do before they take on different kinds of cases.
So let's start talking about what we think those skills are that would be needed to train towards, right? Ultimately, and that's kind of, how about this? We can look at both sides of this, the procedural side and the content side, and say, here are some specifics that we know need to exist in each of these realms. And then we can work to synthesize those into either a hierarchy system, if that ends up being what we kind of feel works the best, or a flatter, more content oriented. I will say, looking at these, the ICWA SJIS crossover and DR, that all sounds like stuff that could come up in any case. Aggravated circumstances, yes, but also if DHS doesn't file it, it's just a dependency case that has a corresponding criminal case, at least until you get to TPR. And then you're still just fighting it at that point. So until they ask to be relieved of efforts, it's less like, okay, cool, you could do this, but you didn't. Unless they're going on something that was unpled. Like if they're going to TPR on something that was unpled in the underlying jurisdiction case. So none of this is set in stone, but let's talk a little bit, since we've had a good discussion on the aggravated circumstances and extreme conduct. Let's start coalescing some of that into concrete things we're looking for. What do we want an attorney who handles this type of case to have as a skill set? Oof, hard question.
So they need to know the rules of evidence.
Base?
Yeah.
Yes.
Skill set or knowledge base?
Right.
Yes. 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 I mean, both could equally be applicable, right? Like, I think knowledge of the federal felony sentencing guide might not be a terrible thing to have here, right? Is it something we need them to have, or is it a knowledge base that needs to be covered somewhere in relationship to this case, right? To give you an idea of how we're handling this in a different area, for extremely dangerous person civil commitments, we are kind of setting up the person who has this certification doesn't need to have this content, like the criminal content knowledge, but someone on the case does. So either they have it or they have co-counsel, right? So that seems like it would fit a little bit here as well. Maybe not to the same degree.
So I think that if we're looking at certifying people without a mentor, I really feel strongly that if they're just coming fresh off the presses and they've just graduated from law school and they don't really have a lot of experience trying cases, which most of them don't. Some of them have done internships, but mostly they don't in an internship get a lot of trial experience unless it's like at the DA's office or something. So I have hired a couple of people that are fresh out of law school, and I don't let them go to court by themselves. I make them follow me around for at least a couple of weeks and just go everywhere I go. Client appointments, they attend. Phone calls, they attend. Court appearances, they attend. And we just co-counsel it. I just put both of us on it. So I think we're talking about, I feel very strongly that if we are going to certify someone and not provide for that mentorship, then they need to have court experience. I just don't think that you can do this without having had a certain number, maybe not trials necessarily, but have been in front of judges for a certain amount of appearances or times or whatever, and have not just know the rules of evidence, because for me there was a big difference between taking evidence class and thinking I knew the rules of evidence, and the first time I was in a contested hearing and gay candidate was on the other side, and everything I said she was objecting, hearsay, and I'm like, damn it, I know that rule. You know, and I know there's a way to get it in because I heard there's always a way to get it in, but how do you do that, right? And so to me there's just a big difference between having the experience of that and having someone follow you around or that you follow around. And so I think those are two different tracks in my opinion.
I don't disagree with you. And keep in mind, like, the certifications are meant to be written towards solo, but we can always say, this is a thing where you can do this without, like, we can have you attached to these cases, but you can't do it on your own. You have to have, like, we have certification under supervision now. Like, that's not a new thing, right? So, yeah, what else? We can either look at bare minimum just to handle dependency caseload. We can look at any of the specific pieces. So I've thrown so far what I've heard from the group as things just in general that people should have in order to do anything in the dependency realm are familiarity with how OPDC support stuff works so that you can ask for help when you need it. Court experience and an understanding of the rules of evidence.
Well, I know this goes without saying, but you have to be an attorney, like a licensed member of the bar. I mean, just
Yes.
as a basic.
we don't certify people who don't have some kind
Right.
of bar number. That's true.
And then also just thinking about the standards, some of the standards and qualifications that we have now, you have to read the juvenile code. Be familiar with ICPC, the UCCJEA. I think, and frankly, the OARs as they relate to DHS. I mean, there's a whole laundry list of things. Sorry, go ahead, Dawn.
Oh, no. I didn't mean to interrupt you.
I just think that one of the greatest areas that is lacking currently is real practical training for lawyers that are newer to dependency, even when they've have a lot of criminal experience and they're, shifting over. It's still so vastly different for a lot of them, and it's very difficult to get qualified, particularly for TPR. So if we can look at like the skill sets that are kind of transferable, if you will, and many of the things are covered in the certifications that we, like the supplemental questionnaire, but like you can get letters from judges, I guess, for an exception, essentially. But maybe those are things that are important at the outset, to have recommendations from people that you've appeared in front of or appeared on cases with that, will provide some level of reference that you actually know what you're doing in a courtroom.
You said something, and I want to piggyback off of that. That you said that there's not you feel like that what's missing as a component is training. Training in what? Because the what there is going to inform what we're looking for here, right? What is the training that you would want to see people have?
I think the training in the content of the juvenile code.
Okay.
Like, right? I mean, I even think when I started, you can certify somebody and act on the assumption that they're going to pick up the code and read it, and they don't. I'm like sometimes occasionally shocked. And I remember getting a case, an immigrant family case, and me like having to hear a judge say that the phrase, and I'm like, well, I better be reading that statute. I mean, shame on me, right? And I was, I was qualified to do the work, but there was no requirement that I had read that know the sections of that code. And so I think skill and qualifications are two different things. Skill standards and qualifications are two different things, because we have this like best practices pie in the sky that we are not reimbursed for if you look through those standards. I look through that stuff. We're not training. We're not expecting you to go and get some of that training. And then the skill to communicate with children, we don't have that. I mean, that should be a qualification for you to work with children. And and that's where which bucket are we getting in? Do we put that skill, and how do we demonstrate that you have the appropriate qualifications to be interviewing an 8-year-old? So is that we don't have that right now. We don't test for it. Should we test for it? We have too few lawyers right here. One big way to solve that is supply and demand. Pay a whole lot more money, and people will invest their time and their resources to getting the skills to make that money. Like many of us do this. I'm not saying we're poor, but many of us do this for other reasons than to get $300,000 a year. But if that was on the table, people would invest a lot more hours into learning the skills and the head knowledge.
I'm training young lawyers who are going to leave me once I can't pay them enough, right? Like it's going to get to a point where OPDC doesn't pay me enough to pay them enough, and they're going to go. And I get that. And it makes me sad, but that's what's going to happen.
I kind of like got off on it, but I'm thinking, when we're thinking about getting new qualifications, are we wanting to put skills into the qualification mix?
I think so, but again, like this is
if so, what and how do we test it?
Right, and so some of this absolutely. Let me put it that I want to write a curriculum for a training, right? Like that is the thing I really want to do. We'll get there. How long it takes to get there is a different question. Whether there are other trainings that we might be able to certify, things that NAPD or other agencies have put together that we could say, in the interim, until we have something developed that's more closely, we at least know that somebody's done this before. We don't have to reinvent the wheel yet. That kind of a thing. I'm on board with all of the idea of this should not be something where you're checking a box on a form that says, yeah, I did this, and then we have no way of really knowing because it's esoteric and who knows, right? Yes, totally understand and agree. Kinsey.
I'll come out and say it. We're broke. I think that, and part of the reason we're so broke is because we do this job because we really feel for these clients. And then you get wrapped into DOMREL cases where you're not getting paid for the DOMREL case, but because it has such a big impact on your juvenile dependency case, you take it anyways pro bono. I digress. If we're talking about creating this certification process for the lowest common denominator, so somebody right out of law school who decides they want to go into solo practice, I came into this job not ever having heard of dependency law before. If we covered it in law school, I must have missed that class. It was not on the bar exam for me. And so coming into it, there was a fair amount that I got from shadowing the attorney who had this job before me. But there's a lot of it that I learned through CLEs. And I think there are some pretty good CLEs out there currently between the CLEs and the bar book. If we're talking about what to put in a training, things that we could pull from, because a lot of this is, we can have a certain understanding of what a permanency hearing looks like, what a contested permanency hearing looks like, what a shelter hearing looks like, or what a contested jurisdiction hearing looks like. But there are so much of the content that we're not going to see. If you have to co-chair two, odds are they're both going to be substance abuse cases. So you're not going to get into the domestic violence things. You're not going to get into any aggravated circumstances. You're not going to get into the immigration issues. And that's going to be really hard to find things to get that practical experience in. So I do think there's a fair amount of it that we have to remember is going to come from the training piece of it. And that would be easy to certify as like a CLE. You show up, you sit your butt in the chair, you watch it, you're there. They can say that you were there. Sorry, that's what I was thinking of.
Okay. I do want to note that we consider CLEs and training to be different. Training is much more active and more involved, and we would be looking like at group participation and taking case studies and working through actually doing the mechanics of the thing while you're learning about it. CLEs are great. Dependency is, a training dependency 101 would be I would envision that as being a much more involved process. So, Holly.
So a couple things, and I think this may be what somebody was saying, but so like, how DHS has not just, and Jennifer, I think, wrote this court training, but like they have the core, that they have to go through. They get hired and they have to do that. That is required of them before they're unleashed, right, on everyone. So if we had something like what you're saying, Kevin, like that would be a requirement. Like, it doesn't matter how qualified you may think you are, like you have to go through this basic core and get all of these various things. So Jennifer Stoller was mentioning like a basic, skills, knowledge. The other thing I wanted to mention is that Annie and I were back and forth a little bit on this on emails the other day, but so much of what I do is not in the courtroom, right? Like so much of what I went to multiple family decision meetings, family engagement meetings today. I was not in a courtroom the whole day. I'm like I'm in family treatment court here in Josephine County now. I'm, attending staffings with the court. I'm talking to every client, like every week to make sure what's going on. I'm talking to service providers. So really as part of dependency practice training, I would think like also about trying to capture those other things. Like obviously we have to go into court. We need to know the rules of evidence. We need to know our way around a courtroom. But I think the social work piece that's become part of dependency work, of the training needs to include that as well beyond the being a lawyer. So I just wanted to mention that.
No, so you're bringing up like the kinds of things that I would agree. Like these are the types of things that we should consider part of the qualification set that somebody who is handling these individually would need to have. You got to know how to handle walking into a meeting with DHS and getting a result for your client that isn't, well, let's go fight it out in court. Not saying that that's not an option, right? But knowing how to walk in and potentially use that, or CRB, right? Like you can get good results out of CRB as well, but those skills may be completely different from what you would use inside the courtroom. And I recognize that CRB is different in various counties, and it may be really a uphill battle in some to get good results, but.
Can we just get rid of CRB statutorily and then just have the court do our reviews anyway?
I think that's a national thing. I think that might be a federal issue, but I'm not.
In our
I'm not
county, if we ask our judge, the judge will replace our CRB with a review instead. All we have to do is ask our judge. But
I don't think you can abolish the CRB is all I'm saying. You can probably get around it, but
Can I
yeah.
Can I just add, so I was in the delinquency group as well, and I know this group would probably agree with these, but two of the skills they talked about were client interview skills, and I shouldn't say two, but thinking of parent and child, and working with both of those types of clients is pretty important to this work. I'll also note that it is 6:07, so I don't know.
Oh man.
Time-wise, how people are doing, but it's been a great conversation, so But I just wanted to point
Yeah.
that out.
Annie, I just want to say that's one of the things that I work with my younger lawyers on is, and it's in both delinquencies and dependencies. A lot of, especially in delinquencies, parents bring their kids to you and you're like, yeah, I'm going to talk to your kid alone. And they're like, the hell you are, right? Kind of thing. And so you got to be prepared for that and ready to deal with it and have a good way to do it. And that can happen also if you're if the kid's in an in-home plan or with a crazy grandma and you're doing a home visit. And so I do trainings with my lawyers on that. You got to talk to this kid alone. And my staff will reach out ahead of time and say, to prepare the resource parent or the grandparent or whoever, the lawyer will need a space to talk to the child alone so that, so there's things you can do. But if you're not part of a group that supports that type of thing and you're just like a lawyer who's starting out, how do you know? And so I think we need to offer that support, I guess, is what I would say.
The other piece is representing children, it's like specifically to decision-making capacity and things of that nature.
So some of that I'm going to just couch as practice standards that we will be developing later, right? We can refer, yes, you have to know and understand what the practice standards are. One of those standards could be, you gotta be able to talk to your kid clients alone, right? Like talking with a client is a confidential thing. You gotta know, like, so knowing how to manage that and be able to get that to occur. Yeah, totally understand. Okay, before we go any further, it is past 6 o'clock. We were only scheduled until 6. We can stick around and keep working for a bit longer if people are up for it. But also I want to be mindful of everyone's time and ensure that, because I think we all have families who enjoy seeing us. And I don't want to monopolize that time. So how are people feeling about, do we feel like we might be at a good break point for today? And I can summarize some of this stuff and send it out. We will want, just so, okay. Okay, so let's go ahead and I think we're at a good break point, at least for the moment. There's a lot of good stuff here. While we may not have really nailed down particulars on the overall structure or all of that, we do have a lot of good information that can be used to define some of those things. So I'm comfortable with us. I will go ahead and put together. So these notes will go into the Dropbox. The transcript from the meeting will go into the Dropbox. Tomorrow, I will have the video from our session converted, and we'll send a link to it for people to review if you want to, and also for folk who weren't able to be here, and a doodle poll link for scheduling the next session, so that everyone is aware. We are looking to have a working draft by the 13th of December. That is, yes, it is a very fast timeline. So the doodle poll will include later this week as options. I don't know how people feel about meeting again within that short of a time frame. We'll see what the doodle poll reveals. But given that next week is Thanksgiving, and I have childcare responsibility on the day after Thanksgiving, there's some availability issues. So with all that said, I think that's it for today. I will send out a follow-up email tomorrow. And Dawn, I will try and include a little bit of an agenda as to what specifically we want to focus and target on at our next meeting. Okay? Anybody have any questions before we head out?
Don't tell me what your daughter's baking.
I don't know what it is, but I can smell it. I'm upstairs and it's wafting
You're
up
teasing
there.
us, Vicky. You're teasing us. I'm dying over here.
I don't know what it is. I just walked in and jumped right on the computer, so I have no idea, but I can smell it.
All right. Have a good night, everybody.
Thank you.
Good night.